Testing, testing. This is internal mic 1.
Testing, testing. This is internal mic 2.
There's 2 more. Let me try this. For some reason, like 1 word.
Hi, Stacy. We are testing internal mic 1.
Now we're testing internal mic 2.
This is microphone number 1.
This is microphone number 2.
This is microphone number 1.
This is microphone number 2. This is microphone number 2. We're testing microphone number 2. I'm also moving the webcam to make sure you can see on the webcam. Okay, good morning everyone and welcome to the Disability Rights Consortium meeting. My name is Rachel Weisberg. I'm an attorney with Equip for Equality and I'm filling in for Barry Taylor, who is out of the office this week. We're just so thrilled to have 2 wonderful presenters here with us today. First, we're going to hear from Elena Duterte. If I pronounced her name wrong, she can correct me, but she's a staff attorney at John Marshall Law School's Veterans Legal Support Center and Clinic. And then second, we're going to hear from Beth Karpiak, who is a staff attorney and Equal Justice Fellow with Equip for Equality's Traumatic Brain Injury Project. The way that we're going to structure today's program is we're going to hear from both of our speakers and then we'll save time at the end for questions and answers. So make sure to keep those questions in mind when we get towards the end of our program. So with that, I'm going to turn the presentation over to Yelena and go from there. So thanks again for being here today.
Thank you. My name is Elena Duterte. I work for the Veterans Legal Support Center and Clinic, and I've been there since 2010 as a student and then as a staff attorney. So I have about 4 years of experience in this area of law. What we're going to go over today is a lot of information. I'm going to kind of skim over some of the more complicated stuff. But if you have questions at the end, please bring it to my attention so I can kind of give you more detail. Also, here's my contact information, phone number, email. You can always ask questions. That's what we're there for. We're there for students, veterans, and attorneys like yourselves. Here's a roadmap of what we're going to go over today. We will go over service connection, before service connection, how you can establish being a veteran. We'll also go over pension, rating disabilities, and kind of the procedural process of the VA. A lot of attorneys and veterans are scared of dealing with the VA and the best process to do that. So I'll hopefully shed some light on the VA process and how best to be efficient and be polite to the VA officials. Also, the Veterans Benefits Manual is the best resource for VA benefits. If you are going to take a case in front of the VA, this is the manual that you will need. It's called the Veterans Benefits Manual. NVLSP publishes this manual. It is detailed, it is thorough, and it really does help in everyday questions that veterans have and advocating for your client. So we will talk about kind of the hierarchy of how the VA is structured. It's the regional office. Each state has its own regional office. Some states, like California, have 2 regional offices. So here in Illinois, it is the Chicago regional office near all of the hospitals like Rush and UIC and Stroger and Jesse Brown. Then from there, it's the Board of Veterans Appeals, Court of Appeals for Veterans Claims, and then it jumps the district court and goes straight to the appellate court in DC, the federal appellate court, and then to the Supreme Court if you're lucky enough. This is not just a straight up and straight up. You go up the system and you keep appealing, you can get remanded. A lot of cases do get remanded. So be aware that a case can go to the BVA, to the CAVC, and then right back down to the RO. So that happens a lot, and it can frustrate a lot of attorneys and veterans. First, we'll talk about basic eligibility. Basic eligibility, we'll go through this statute. This is what a veteran is. The 2 main components of this statute are active and all conditions other than dishonorable. So it sounds pretty clear, but there are some little caveats to this. We'll talk about character of discharge. Character of discharge, most people know about honorable discharges, but there are other discharges that veterans can receive, or service members can receive when they get out of the service. There are honorable, general, other than honorable, bad conduct discharges, or BCDs, and dishonorable discharges. Typically, honorable discharges are you get every benefit as a veteran. General discharges, you usually get most benefits, but you won't get the GI Bill. So it's a big issue for veterans who get general discharges. BCDs and OTHs, those are, sometimes you can get benefits from the VA. What the VA will look at is what happened in service that brought you to a lower discharge. Is this something that maybe there was an underlying issue like PTSD or addiction, something that may have been caused by your service, and that is the reason why you got this lower discharge. And then there's dishonorable. Dishonorable, you really won't get any benefits with that. There are some little exceptions, and you can find case law on that. But typically, dishonorable discharges, you will not get benefits. There are things called discharge upgrades. And discharge upgrades are great, but they're really hard to get. You have to show that it was, the court martial, if you got a BCD, or the administrative discharge, if you got an OTH, would be something that is, unfair. So you'd have to show that the whole process was kind of unfair, that they didn't give you proper representation, that kind of thing, that they would give you, they would change your discharge. There's actually a case where a veteran had a OTH. He brought it to the attention of the DRB, which is the Discharge Review Board. The Discharge Review Board realized that, wait, you shouldn't have been discharged other than honorable. They really messed up. Let's give you an honorable discharge and then extend your period of service for 2 more years because that was your contract. You probably would have done that. Well, he got injured off active duty, like when he was done with service, but it was technically in the time period where they extended his active duty service. So he got benefits for something that didn't happen while he was in service because of a discharge upgrade. So it's really important that discharge upgrades, that you consider discharge upgrades when a veteran comes to you with a lower than honorable discharge or a bad conduct discharge. The other requirement is active military service. We have a lot of reservists and National Guardsmen, so you have to remember that when they're not on active duty, that time is not considered as a veteran time. They don't consider that for purposes of service connection, which we'll talk about in a little bit. So figuring out when they were active, when they were inactive is really important for some of these cases. Training can be considered active duty. So when a service member enlists and then he goes off to active duty for training and then is still in the reserves and doesn't go at actual active duty, that time is considered active duty. So there are times when you are considered active duty, even if you're not, if you're a reservist or a National Guardsman. This is the most important area of VA benefits. Service-connected disabilities is the way to get the most money from the VA and for your clients. And here is the fun statute. We'll go through all of this, so you don't have to read it in detail, but this is where it all really comes from. There are three main requirements. The first one is a current disability. It's pretty simple that you have that disability right now. An in-service occurrence or aggravation of the disease or injury. And last is a link between the two. And we'll go through each one of these. So it sounds simple on its face, but I always tell my students and veterans, this is the most important slide that you'll ever see. These three requirements is what the VA is looking for. So if you don't remember anything else from this presentation, this is it. Evidence of a current disability. Pretty much you need to get a doctor to say you have this disability. Typically it's in their medical records, it's in their VA medical records. The VA will schedule a compensation and pension exam to make sure you actually have this disability. It's a pretty easy one to establish. You can look at the symptoms of a veteran, and if a doctor won't actually say he has this disability, sometimes medical treatises will help establish that he actually has this disability. Chronic fatigue syndrome is a big one because a lot of doctors will not diagnose you with CFS because it's not really clinically, it's not defined well enough for doctors to say you have CFS. So sometimes you have to look at medical treatises and put together with your symptoms and try to prove that to the VA. The next is an in-service occurrence or aggravation. This area is not like it's like workers' comp, but it's not. And this is the reason why it's not like workers' comp. It doesn't have to be in the line of duty. It doesn't have to be while you are on base. It doesn't have to be while you're deployed. This injury can happen at any time during active duty. So when you enter service, and during the time that you entered, between the time that you entered and you exited service is when you're considered an active duty. So a lot of people will be playing basketball and twist their ankle. Or we had one guy who was in he was in the mess hall and there was a food fight and someone threw a can at his head and it resulted in TBI. So there's things that happen that are not really in the line of duty, not in combat, not what you would think of a veteran receiving benefits for, but this is something that can happen. Even car accidents during active duty are included in this service connection. It's a very broad statement. You don't really need medical evidence to show that it happened in service. Here are some examples of lay evidence that will be sufficient. Buddy statements are great. If you know someone that was in service with you, and they're willing to write a letter about something that you guys both experienced, or he remembers you going, you limping around this one day after you guys played basketball, that's really helpful for the VA to corroborate your story. So getting a buddy statement, obviously service medical records if you actually went to a medic, but also if you were in combat, sometimes you sprain your ankle or you twist your knee or you hurt your back, you're not going to go see a medic if you're in combat because you see people who are in way worse condition than you are. And you're like, you know what, I need to just go through this, deal with the pain, and it'll go away. I'll just take some Advil. And this other guy, he maybe lost a limb and you saw that and you're like, I can't go to sick call. I'm not as bad as these guys. So a lot of people will not go to the medics in the service. So that's why the VA takes these lay statements into consideration. Also, we have a lot of veterans, World War II or Vietnam, who don't remember who they served with, or they've passed. So getting newspaper articles to corroborate what happened around that same time. You tell your story and you remember these big events happening, and maybe it was newsworthy that back then they would have, in American news or in, foreign news about this, one, mortar attack, or this ship was, was getting shot at, something like that. So these newspaper articles are helpful too. Also, just the statements of the veteran are really helpful for the VA. It's surprising sometimes that veterans think that that the VA knows what happened to them. But really, sometimes they don't have enough records. So just your statements alone can really help a claim and getting everything in writing to the VA, and that it will just make everything easier for the VA to grant you that disability. The third element is the connection between the current disability and what happened in service. This is the hardest requirement to get. What do they call that? The standard of proof for this portion is called as likely as not. It has to be a 50% connection between the two. So a doctor would have to say it's as likely as not connected to this thing that happened in service. Sometimes it is hard to get a doctor to say those magic words, but if you can get a doctor to say that this back injury was from carrying 70 pounds of with a backpack and all of his armor on, that would be sufficient. It is not preponderance, it's 50%, so tie goes to the runner. Here are the 4 legal theories that we'll talk about for nexuses versus direct service connection, aggravation, presumption, and secondary service connection. So we'll kind of go through those. The most common is direct service connection. Direct service connection is this directly caused this. It's pretty straightforward. The harder ones are hearing loss. You were around all of these mortars, or you fire a lot of guns, you can get hearing loss from that, but maybe when you get out of the service, it's not that clear that you have hearing loss. But over time, it is clearer that it's kind of a slowly progressing disease is hearing loss. So showing that something that happened 30 years ago caused your hearing loss, it's pretty hard to do. But we do have, there are doctors and there are medical treatises that speak to that, the delay of hearing loss. The next is aggravation. Some veterans don't come into the service with a clean bill of health. So sometimes the VA will say, no, this is a pre-existing condition, and this is the normal progression of the disease. Well, if you look at aggravation, if something aggravated that disability, it's just like as it sounds. So you have to show that when you entered service, it was X, and when you exited, it was worsened over that time. You don't have to show a particular incident, but you can show, just the progression of your time in service on your disability. The next one is presumption. Presumption is one of the most interesting kind of legal theories, because the VA will recognize certain disabilities that are related to certain places and times in the service. So the most common one people know are Agent Orange presumptions. If a veteran stepped foot in Vietnam, he is presumed to be service connected for diabetes or ischemic heart disease or non-Hodgkin's lymphoma, Hodgkin's lymphoma, prostate cancer, a lot of different disabilities. So if a Vietnam veteran comes to you with one of the listed disabilities, it's a pretty easy slam dunk case. Those cases are sometimes wrongly decided, but if they have an advocate on their side to kind of put it in, show them that this is, he was in Vietnam during this time and he has this disability, it's a pretty easy nexus. Also, the current veterans who are coming out from OAF, Iraq, and OEF, Afghanistan, and the Gulf War have other disabilities that are presumptively connected. So malaria is one of them, or chronic fatigue syndrome. Also like irritable bowel syndrome, so IBS. Certain disabilities are being connected to service. Right now, they are getting a registry together of all the veterans who are exposed to burn pits. So in the beginning of the wars, they would burn their fecal matter, they would burn kind of anything they could burn because they had nowhere to throw it away. So they burned it, and people would be inhaling this trash, essentially, and they don't really know what the medical effects are. So they're making sure they get a list of all the service members during that time, and they are going to come out with disabilities. So they're going to do research and find out which disabilities are more prevalent in this group of individuals, and they will make presumptions. So that'll probably be 10, 15 years down the line to see what disabilities are actually more likely to happen in this group, this population. The next one is, or the last one, is secondary service connection. This one I like to talk about all of your joints and how they're all connected. If one thing is, say you have a knee service connected and it's affecting your hip, which is affecting your back, that can all be service connected. So it's not just what happened in service, how does it affect the rest of your body? We've had veterans who had PTSD, and because of that PTSD, they started drinking and they became an alcoholic. That could be service connected. So things that initially happen in service, and then things that cause that, that are caused by that service connection disability, can also be connected to service. There's also a fifth theory of service connection, but it's definitely mislabeled. It's called 1151 claim. It's when veterans are getting treatment from the VA and there is medical malpractice. So it's outside of service, so it's not really service connection, but they treat it the same way. So it's medical malpractice. It's kind of another way to get the money that you deserve if you don't file a Federal Tort Claim Act. So that's just the other one, which I will not speak on that much today. Also, the benefit of the doubt doctrine. The VA will give you the benefit of the doubt. This is the 50-50, weighing of the scales. If the evidence is kind of equal, they have two experts that they weigh equally that have differing opinions, they will give the tie to the runner. So they will give it to the veteran. So this is the one area of law that has lower than a preponderance of the evidence standard. I'm going to speak briefly on establishing disability percentages. So once somebody is service connected for a disability, they will rate that service connection on a percentage scale. These ratings are based on generally based on how this disability and the symptoms of this disability would affect your employability, or a general person's employability, not particularly your employability. The VA will, like I said earlier, will schedule these C&P exams, these compensation and pension exams, to establish what rating you should receive for this disability. They're in 10% increments, and here's an example. This is not the best example of how to rate somebody, but it really does show, if your thumb and what it's worth, your major or your minor hand, if it was amputated. And so you can see each finger is worth a certain amount of percentage. So if you lost your pinky, it's worth less than losing your thumb to the VA and your employability. And they have these ratings and diagnostic codes for pretty much every disability. So in the Code of Federal Regulations, they go through, your musculoskeletal. They go through mental disorders. They go through neurological disorders. They have different sections for each part of the body. And what I like to call VA math is really frustrating to a lot of clients. We have veterans who come to us and say, okay, I have a 70% rating for PTSD, I have a 30% rating for a back, and I have a 20% rating for a knee. Why don't I get 120%? Well, the VA likes to treat you as 100%, so we can't go over 100%. You are one full 100% healthy person. And how the VA treats you is they will take the highest percentage and say, okay, we have 70% of a disabled person for PTSD. All right, so now you are 70% disabled and 30% healthy. So now they look at only the 30% healthy, and they're like, okay, 30% of 30, I know you guys all like math, 30% of 30 for the healthy portion to show what your back injury is. And then from there, they take the rest of the percentage, I think is 21%, and they take 20% of that. And that's how they calculate your disability. There's an easier way to do this. There's like a graph and stuff if you're interested in seeing how they're added up, but there's a much easier way to do this. But this is how the VA rates you. And so instead of being 120% disabled, he's only 80% disabled, and he is not happy. So you kind of explain this is how the VA rates you. You can't. This is just how the process is. There are other. We can see if we can increase your other disabilities to make you 100%, but we can't get you to 120. But there is a way to get to 100% without actually, showing that his disabilities or her disabilities are worse. There's a thing called TDIU, Total Disability Due to Individual Unemployability. This is you have to show a couple things. You have to show that you're unable to work because of your disabilities, and that one of your ratings is at 60%, or if you have two ratings, one has to be at least 40 and equal 70. It's just the way that the statute's written. But it is a great way to bring your veteran from 70% to 100%. That's over $1,000 difference a month. So this amount is just drastically different. A 10% rating right now, I think, is $130 a month, but a 100% rating is like $2,700 a month. That is a good that's good income for somebody who is unable to work because of disabilities that happened in service. I always warn my clients about the VA's possibility of decreasing their ratings. If their disabilities have gotten better, there could be a chance that the VA will decrease their percentage and then decrease how much money they receive. The VA will tell you when they're going to do it, and they'll give you 60 days to respond. If you respond to it, they'll keep your rating at the same percentage, and then they'll reevaluate you, and you can make your arguments on why you should be kept at that same percentage. So the VA does give you some notice when they're going to decrease you. But when veterans see this, they're like, wait, I've been at 70%. I don't know why they're bringing me down to 50. And sometimes it's because let's say it's for PTSD, the medication's really working well. They're having less symptoms. They are getting better as the VA likes to treat them. And so when they see that, the VA sometimes will act on their own and decrease them. Typically, the VA doesn't act on their own. Typically, it's when you ask for an increase and they realize that you actually have gotten better. So I do warn veterans that if you do this, there is a possibility that they will decrease you. So I like to look through their medical records way before we actually refile to see if they qualify for a higher percentage. I don't want to put them in a worse position than they already are in. I'll quickly talk about non-service connected benefits. This is the other benefit. Veterans will not be able to receive both service connection benefits and non-service connected pension benefits. They're wholly separate. Also, this is not like pension, military retirement pension. This is a completely different program. So this is just an internal VA program, and it's a needs-based program. The three requirements for this program are wartime service, total disability, and need. Wartime service sounds like you'd be in combat, you'd be deployed. That's not what it is. It's you just be in the service for one day during one of these periods of time. So right now, since 1990, we are in a period of war. So all of the current veterans are meet this requirement for a non-service service-connected pension. So you'll see these are the most relevant ones. Obviously, there's like World War I and the Spanish-American War, but we're not going to put that on here because you're probably not going to see clients from the Spanish-American War. If you do, I want to meet that person. The next requirement is permanent and total disability. This is you have to be 100% disabled by any means. So it doesn't have to be a disability caused by service. The way to get around that is the client has to be over 65 or in a nursing home. but don't tell your client that he is totally and permanently disabled because he's 65. He probably will not hire you or like you very much. It is just an exception to the rule. So if you're 65 and older, you meet this criteria. The last portion is the needs portion. This is the make or break of why most veterans do or do not get this amount of money. The MAPR was about $12,000 in 2012. I think it's probably $500 more now. It might be at like $13,000. This is it's the top rate. So if you make more than this amount, you won't get pension. It's a needs-based program. So if you make $1,000, you will only get $11,000. So it'll equal out to the $12,000 typically on how much you make. If you make $5,000, the rest will be paid by the VA. Here are some kind of exclusions and deductions that you can show from your income. So some welfare doesn't count towards income. The most important one that advocates should know is medical expenses. If a client is spending a lot on medical expenses, that can be reduced from his income. So you should really be aware of how much you're actually spending on medical. Some of these clients are getting medical from the VA and aren't spending that much, but other clients are going to be spending it, at different places. Also, the VA still does not have a look-back period. Like, as you know, in Medicare and Medicaid, there's a look-back period. So look 3 years back to see if you sold any of your assets, to see if you are reducing how much you're worth, your assets. The VA currently does not have that look-back period. So I don't know much about, trusts and estates and stuff like that, but, attorneys will get around this rule by putting things into trusts. At this point, Congress is looking to put a look-back period on VA pension and such, so that people do not try to get around this rule. The pension is different than service connection because there is a yearly requirement. A veteran has to report his annual income so that the VA can change how much he's getting paid, each month. Sometimes a veteran will, get less money and should report it, or is making more money and should report it. The bad thing about this annual reporting period is a lot of people forget about it and forget to report when they make money.
They've changed that as of last week, and it's now going to be, the VA is going to check with the IRS and Social Security to check their wages. So
Well,
no longer a VA report.
Okay. David Bryant just said that this year, or this last week, they're going to look at IRS and Social Security to look at their reports to see if they were getting more income than what they reported to the VA, which is very exciting, so that overpayments will less likely happen. But if it does happen to your client, the failing to report is pretty awful, because the VA will slowly realize that, wait, this guy hasn't reported in 3 years, and they will look back 3 years and they will say, wait, you've been making way too much money. We want all of that back. So you'll see these $50,000 bills or $35,000 bills. And it's really scary when a veteran who's making not that much money, let's say even $12,000 a year, who now does, is making too much money for this program, has to be all back. And they come to you frightened, and they're like, I don't know, I can't pay this back. There's no way I'll ever pay this back. There is some light at the end of the tunnel. There's a couple different ways you can go about this. You can dispute it. You can say, this amount's incorrect. Here are all my bills from the last 3 years. Here is my income. It should be, like, my bill should be much less, or shouldn't be there at all. Or you can ask for a waiver. A waiver, you have 180 days to contest, or not contest, to request that the VA waives this debt. That, even though maybe I forgot to report, it wasn't something that it wasn't intentional. I wasn't trying to, be fraudulent. It's something that I forgot. I don't have the money. Kind of more of a sob story than it is disputing the hard facts of how much money you were getting. I've seen the VA approve these, and I've seen them deny them. They are they're hard to get granted when the amount is so much, like $50,000. But the VA can reduce a portion of it through waiver. Survivor benefits are important. At this point, a lot of the Vietnam veterans who are plagued by these diseases that are presumptively connected to Agent Orange, like prostate cancers or lung cancers, can pass away from these disabilities. And their spouses are now looking for compensation for this. There are three types, I guess. I'm going to put it, accrued and substitution, DIC, and death pension. Accrued benefits it's not its own benefit, but I'll talk about that in a second. There are a few qualifying relationships, so you can't be an aunt and get benefits for your nephew, but it is the spouse, child, or a dependent parent. So the parent is a harder one to prove, but if you are, if you lived with your son or daughter who is the veteran and they supported you financially, you could apply for this benefit. Typically, not all three can apply at the same time. It's usually spouse, there's no spouse, then child, there's no child, then dependent parent. So that's the order that it goes in. Surviving child, pretty simple, biological, adopted, stepchild, has to be under the age of 18 or under 23 while going to college, or there's a exception where it's the helpless child exception. If they before the age of 18 were not able to support themselves, when they were always dependent on their parent. It's pretty clear cut, the helpless child. So some children will come to us at the age of 40 and say, I was depending on my parent, I never had a job, I couldn't get a job, I have these disabilities, that's why I was relying on my parent. Those individuals can get this benefit as well. Accrued benefits, I call this it's not a good thing to do. Don't ever ask for accrued benefits, because there's something else that I'll talk about in a second. But essentially, is if a serviceman or a veteran is looking for benefits and was in the process and he passes away during that time, the spouse can ask for accrued benefits and they will make a decision on the benefits that when the veteran was alive and can pay the spouse or child that amount of money. But if you ask for accrued benefits, you can't appeal that decision. But in substitution, it's the same thing, but you can actually appeal it. So if a veteran is applying, he's been waiting, because we all know the VA is taking a little bit of time to adjudicate these claims. The spouse can come in and say, I want to substitute myself for my husband, and step into his shoes. So if they grant benefits, they can get the benefits for when the veteran was alive. And then if they don't grant, or they get a lower percentage than they want, they can appeal it. So that's the good thing about substitution. The best benefit is the DIC, Dependency and Indemnity Compensation. There's a couple things that you need to know about DIC. It has to be a service-connected death. So if a veteran died of a service-connected disability, that will give the spouse, child, or dependent parent that benefit. There are also some 10-5-year rules. The 10-year rule, if a veteran was 100% disabled for anything for at least 10 years, then anything that he died from you can get DIC for. So say he was 100% disabled for PTSD, service-connected, and he was there for 10 years, and then he passed away from a heart attack or kidney cancer. You can get DIC. So there's other ways around it from it just being service-connected. There's a couple caveats to entitlement to DIC, but it's really to provide continuous support of the spouse or child. As I said earlier, spouse is first, child is second, and then dependent parent is last.
Raina,
Yes.
what about the ex-spouse?
Typically, the ex-spouse cannot get it. So if you have to show that it's that the disability was service-connected, caused the veteran's death, you just show it was in whole or a major part of the of why he died. So it can be contributing, but it has to be substantially or material part of that death. Death pension is very similar to non-service connected pension. If they meet the same requirements as the deceased veteran, they served during a war period, that there's the disability portion and that there's a need, you can get that too. That doesn't happen all that often. I typically see DIC that spouses are looking for. We're going to talk quickly about how to go through the procedure of it. As I said, there are the 5 steps to this. The regional office is here in Chicago, and if you have a client and they're at the regional office, I would advise you to go there, speak with them, find out where it is in the process, put a face to this case, and if you're nice enough, sometimes you can get documents if you don't have some of the documents. You can request those from the regional office, and they're pretty nice about it. So be kind, be polite. Here are the types of claims you can file at the regional office. New and original claims, things that the VA has not seen before. Reopened claims. So if a veteran was denied for a disability and then does not appeal it and it has gone 10 years later and decides to file again, you can file it again, but you would need new and material evidence. And there's a thing called CUE, or clear and unmistakable error. That is considered a new claim, but it's an old claim. You're saying that back 20 years ago, you guys really made a huge error in this case, and you should look back at it and say, you know what, we did, and give me all of my retroactive benefits to that date. So that's one of the big benefits. It is the hardest one to get, but if you can establish clear and unmistakable error, that is really important and can be a big financial benefit to the veteran. There's a big push for fully developed claims in the VA. The VA has been pushing this because statistically in the pilot program, the claims were getting processed very quickly. I've heard 125 days, I've heard 200 days, very quick in comparison to what the VA is doing currently. And so the FTC has a kind of caveat. It has to be new claims. It cannot be a reopened claim. You need to sign an FTC certification. So it's just a paper, and you sign at the bottom saying, I want this to be part of FTC. The one big benefit, actually it ends in August of this year, if you file within this August 2013, August 2014 for FTC, you can get a whole another year of benefits. So they will push back their effective date 12 months of benefits. So if I filed today, usually my effective date would be today. But if I put in a fully developed claim with all of my evidence and everything is there and I can just submit it, they will give me 12 more months of benefits. So it's kind of a carrot for veterans to file with all of the information there so that the adjudicator can just look at it and say, I have everything, I can actually make a decision without requesting more evidence.
I'm going to interrupt you just really quickly. We had a request from one of the viewers online if you could state the slide that you're on just so that they can follow along more easily. Or just say when you're going to the next slide.
Yeah.
Thanks.
All right. Fully developed claim slide is where I'm at. I think it's number 53. And I'm going to go to the next one. The Disability Benefits Questionnaire is a new development in the VA. They have about 70 of them, I believe, and they have different forms for different disabilities. So it makes it easier for private physicians to look at your disability, look at your symptoms, and determine what your rating would be, and it would kind of give them more of a form where they can just cross out boxes, look at all the disabilities, and find out what the VA looks at to rate you. So it's very helpful for a private physician who doesn't really do this type of work to see this. Now we're at the Varro administrative appeal. So most, well, I'm not going to say most, some veterans get denied at the initial stage or get a rating that they're not really happy with. And there are, this is kind of the procedure on how to appeal a claim. The first one is a notice of disagreement. And that has to be filed within 1 year, 365 days. This is not the best slide because you probably can't see it very well, but it is the claims process. I will probably send out an email, and I can probably send it to you with what this actual attachment looks like in a bigger sense. This notice of disagreement is now a form. It's no longer a letter you have to send into the VA. The VA wants you to fill out a form, and it says which disabilities are you disagreeing with. You know, are you disagreeing with you know, if you had 5, are you disagreeing with all 5, or just 3 of them, or 4 of them? They will ask you if you disagree with the rating, or just disagree with the denial of service connection. I'm a little short on time, so I'm going to try to go through this quickly. You can pick a DRO, a decision review officer, and this decision review officer will re-look at the claim with a new set of eyes. So they will not look at the old decision, and they will look at it on its face with all of the evidence in front of them. If you do not pick the DRO, you can pick the traditional review, but they will still give you a statement of the case, which is essentially the VA's argument on why they were correct in their initial decision. You can keep submitting evidence during this time, so be aware that you can still submit new evidence that the VA has not seen to the VA, so that they will correctly grant you benefits or correctly rate you. If after a statement of the case comes down and you submit additional evidence, the VA can give you a supplemental statement of the case, or an SSOC, which is just looking at the new evidence and then putting it to the law. From the statement of the case, you have to file a Form 9 appeal. This Form 9 appeal is a 60-day deadline, so it's a very quick deadline compared to the NOD, which is a year. This is only 60 days, and it just it's on a Form 9, and you just say, I disagree with this, and you don't have to put your full brief in there or all of your arguments. You can let them know that you will be submitting additional arguments. The next portion is just about the BVA going to DC. You can look over this if you have any questions about that portion of the BVA process. They do have a traveling board hearing who comes to Chicago twice a year. They're actually coming in April this year, and they schedule about 100 hearings during that week. They're here, and it's a really good experience to have a administrative law judge or a veterans law judge speak to you about the claim, and they're really honest about how to what they would need to grant the claim, or what would be helpful for them to really look at all the facts. But at that point, I think we can send this over to Beth, since I took about 45 minutes. That's great.
Well, yeah, thank you so much. It was so much
course.
great information, and we'll turn the stage over to Beth.
Oh, okay, great. Hi, my name is Beth Karpiak. I am a recent graduate of Loyola University Chicago School of Law, and I'm going to be talking about my Equal Justice Works Fellowship Project, which I've titled the Traumatic Brain Injury Rights Project. And on the slide here you can see I am sponsored by Greenberg Traurig and Walgreens. So this is a 2-year deal. I have 2 years of funding by Walgreens and Greenberg Traurig to be doing this work. And it's hosted by Equip for Equality, so I'm a staff attorney at Equip for Equality. And as we move forward, you're going to be hearing me talk about my project as TBI for traumatic brain injury, so TBI, traumatic brain injury. So I'm going to talk about my project, legal strategies that I'm using within my project, and then to kind of piggyback off of Elena, some strategies we're doing within the project to serve veterans. Moving on to the next slide. So I'll start with a quick overview of the project, and then I'll do a brief little training on what is traumatic brain injury and how traumatic brain injury is related to abuse and neglect. Then I'll go into the project components, and that's where I'll talk about the veteran outreach efforts that I'm doing. And then we'll close with some legal issues that I'm seeing, legal strategies to address those issues, and then some case examples. So the goal of my project is to protect individuals with military service and recreation or sports-related TBI from abuse and neglect. And my project is housed within Equip for Equality's Abuse Investigation Unit. And I know that several of you are probably familiar with what Equip for Equality does, but not everyone is familiar with what the Abuse Investigation Unit does. So I thought I would read our kind of mission statement to give you some background. And I also like this. So the Abuse Investigation Unit at Equip for Equality protects and enforces the fundamental rights of people with disabilities to live safely and in an environment where their choices and preferences are supported and their individual needs are met. So a lot of our clients are individuals with disabilities that are living in healthcare facilities or are living in the community and receiving services for their disabilities. We kind of accomplish this mission by taking on individual cases of abuse and neglect, and then also doing systemic monitoring of abuse and neglect at facilities that serve individuals with disabilities. So in the past, Equip for Equality has not had the resources to reach out to and meet the needs of individuals with traumatic brain injuries. We have some funding for TBI, but it's really small. So this project is going to greatly expand the availability of legal advocacy services for individuals with disabilities. Moving on to the next slide, slide 4. So what is traumatic brain injury? The CDC has a really simple definition, and I have it for you on the slide. It's an injury to the brain caused by the head being hit by something or shaken violently. This injury can change how the person acts, moves, and thinks. So a pretty simple definition, but the symptoms and the effects that TBI can have on an individual are very complicated, and I have some of them on the next slide. So generally, individuals who are diagnosed with a TBI have changes in one or more of the following areas. And it's a lot of different areas that affect every part of your life. So thinking and reasoning, understanding words, remembering things, paying attention, solving problems, thinking abstractly, talking, physical activities, seeing or hearing, and learning. So something that can affect any part of your life, including physical changes and then also cognitive changes. Moving on to the next slide. So that's how TBI can manifest in one individual, but I want to talk a little bit about the big picture with TBI and the need for this project right now. So 1.7 million people in the US are diagnosed with a TBI each year, and that's from the Center for Disease Control. And then this number, 280,732 members of the military have been diagnosed with TBI since 2000. And every time I do this presentation, I have to update that number because it's changing every day, getting bigger every day. And then finally, the CDC is also reporting that sports and recreation related TBI is on the rise. So with those stats in mind, how does TBI relate to abuse and neglect? Well, generally, people with disabilities are 4 to 10 times more likely to become victim of abuse, neglect, violence than people without disabilities. Victimization can occur anywhere. It can occur in the community. It can occur at work. But generally, institutional settings are high-risk locations. These are places where individuals with disabilities are in a way siloed away from the community. They have limited control over their own environment. They have a schedule of how things work every day, and that's how they have to do it. And also these types of locations, these types of situations are away from the eye of law enforcement or from people who would otherwise report instances of abuse and neglect. And then in addition, some other factors that contribute to abuse and neglect among people with disabilities is unemployment or underemployment. So these high rates of unemployment or underemployment in people with disabilities leads to lower income, less choice about where you live, less choice about who your caregiver is, less choice about what facilities you can live in. So that lack of choices can also lead to an increased risk of abuse and neglect. And then even if someone does have adequate financial resources, they may not have control over those financial resources. So someone who receives disability benefits may have a rep payee, and that rep payee is in charge of making their financial decisions. Or someone with a guardian, someone has a guardian of the estate who's completely in control of their financial resources. So that lack of control in those types of relationships can also lead to increased risk of abuse and neglect. Moving on to the next slide, slide 7. So there's also some specific factors in relation to TBI that lead to increased risk of abuse and neglect. And so I want to emphasize that with a brain injury, no two brain injuries are alike. Someone can have a very similar injury as someone else, and one person might have physical disabilities as a result of the injury. They might have trouble walking, they might have trouble talking, where the person with the same injury might have what's kind of referred to as an invisible injury, where they don't have any problems with physical issues, but might have a cognitive disability or difficulty reasoning. So sometimes a person with a TBI can have difficulty with executive control. And this is kind of an umbrella term for management of the cognitive processes. So this can lead to difficulty following rules due to maybe an impaired understanding, difficulty with problem solving, and difficulty with anger management. So these types of issues, this difficulty with executive control, may prompt others to respond to these behaviors with undue physical force or inappropriate medication, because these symptoms of the TBI are manifesting in such a complicated way that's difficult to understand. Oftentimes it's dealt with by over-medicating the individual, calming them down so that someone doesn't have to deal with that. Also, people with TBI may have difficulty with memory and perception. So even if they are a victim of abuse and neglect and want to report it, they might not have the ability to do so, or in a way that someone perceives as an accurate report. So even if someone has the physical ability to make a report that they're a victim of abuse and neglect, the way that that's perceived might be that the person's making it up, or that this is a manifestation of their disability. And then some additional factors that are common with TBI are substance abuse. There's a big link between individuals that have TBI and substance abuse. Settlements from personal injury cases. A lot of times the way in which a person gets their injury may result in a fairly large settlement from a PI case. And this type of money associated with this person can cause people to prey on them. So we see that a lot too with individuals with disabilities that have fairly large estates. Moving on to the next slide, which is slide 9. So in addition to those side effects or symptoms of TBI, it can also cause a wide range of functional short or long-term emotional changes. So different types of mental illness issues, depression, anxiety, personality changes, aggression, acting out, or social inappropriateness. So someone who prior to their injury was very polite and maybe somewhat reserved, after their injury might have no filter and says, things that they wouldn't normally say in public, causing them to kind of be subject to victimization. And I want to point out quickly that there's studies that say it goes both ways, that TBI causes these types of emotional changes, or also that people that are predisposed to these types of issues are more likely to get a TBI. So for example, someone who frequently engages in risky behavior, riding a motorcycle with no helmet, or getting in fights at bars frequently, is at a higher risk of getting a TBI. And vice versa, someone who has a TBI, after their TBI might develop these types of risk-taking behaviors because of their injury. And then also it's common for TBI symptoms in veterans to overlap with PTSD symptoms as well. So how am I going to address these problems within my project? I've proposed a project that has 3 strategies. So it starts with community outreach, individual legal advocacy, and then system-wide monitoring. And I'll go through each one of those. So the community outreach is one of my favorite parts, and I think a really integral part of this project. And it's a lot of what I'm doing right now because I'm still in the beginning of my project. So the point is to provide potential clients with information about self-advocacy, legal rights, and the services that are available to them through the project. And this is important because Equip for Equality hasn't served a large number of veterans traditionally in the past. So a big part of this project is getting the word out about Equip for Equality services to veterans and individuals with TBI. So I've been doing presentations at TBI service providers, TBI support groups, and different healthcare facilities. And I'm in the process of negotiating an MOU with the federal VA facilities in Illinois to be doing quarterly trainings and legal clinics at the VA facilities. And so I think that would be a really big step in making EFE services known to veterans with disabilities. And then speaking with veterans, I've also come to know that some veterans are not trusting of the VA system and try to stay clear of the VA. So I'm also talking with the VFW to do some outreach presentations at their locations so I can kind of meet veterans where they are and make people feel more comfortable. And then kind of the meatiest part of the project are the individual legal advocacy services. And I've listed some examples of how I can help clients with these issues. So ensuring access to appropriate individualized services. So if we have a client in a nursing home who needs to be getting rehab therapy and they're not, that's something that we would be able to advocate for them. Challenge individual restrictions of rights. So if a person is living in a facility or in the community and receiving day programming and they're not allowed to use the phone for whatever reason, maybe because the caretaker thought it would be easier if this person didn't get to use the phone and they wouldn't have to watch them use the phone, that would be something we'd advocate for them to be able to lift that restriction. Facilitate access to state and federal investigatory systems. This is something I'll talk about a little bit later in the presentation, but generally specific state agencies are responsible for investigating abuse and neglect of people with disabilities, and we can help individuals with disabilities access those different systems. And then compel action by state agencies and service providers. So if there is an issue of abuse and neglect with a service provider, we can enter into negotiations with that facility to remove the abusive conditions and provide services that would prevent abuse and neglect. And then also compel action by state agencies, which would be if an individual is not happy with how a state agency investigated their claim of abuse and neglect, we'd be able to provide oversight of that investigation and compel the state agency to make appropriate plans of corrections and make sure that the facility is following through on what they need to do. And then finally, ensure access to the justice system. And then the final prong of the project is system-wide monitoring. And this is probably what is most foreign to a lot of people who are outside Equip for Equality or even outside the abuse investigation unit. Because our monitoring activity is reliant upon some really excellent statutory authority that Equip for Equality has as the protection and advocacy system in Illinois. So as an attorney with the Protection and Advocacy Agency in Illinois, I have the right to observe all areas of facilities where individuals receiving services have access. So walk in unannounced to a facility that we suspect may having issues with abuse and neglect or quality of care or rights restrictions, walk in unannounced, meet with individuals that are in the facility, take a tour of the facility, and have access to any of the areas where individuals receiving services have access. We also have the ability to obtain reports related to abuse and neglect investigations, quality assurance and licensure, obtain reports related to restraint and seclusion, and obtain records related to individuals who have died. So as part of the project, I'm going to facilities that serve individuals with TBI, making sure that individuals' rights are respected and their needs are being met. I've currently am doing an investigation of this facility that specifically focuses on serving individuals with TBI and looking into some restraint issues. And if we get time to it at the end, I'll talk a little bit about restraint within facilities. So now we get to the legal training part of the presentation. While legal rights are defined in several different statutes depending on where an individual is receiving services, all the legal work we do in the Abuse Investigation Unit comes down to this very basic legal right. And it's regardless of where a person with traumatic brain injury is receiving services, he or she has the right to be free from abuse and neglect. And this is really basic, and we often take it for granted, but this is the most important legal right that someone has while they're receiving services. So the first issue I want to discuss, and I mentioned before, was reporting abuse, neglect, and exploitation in Illinois. So state agencies are responsible for investigating abuse, neglect, and exploitation of individuals with disabilities. You would think that reporting abuse and neglect of an individual with a disability would be simple, that you would call up one number and that everything would be taken care of, but that's not the case in Illinois. Depending on where the person is living or receiving services, that depends on where you're going to call to make the report. So issues that we see a lot are people are unaware of where to make their complaint. They might be uncomfortable making the complaint. They might feel that they don't have the ability to accurately make the complaint. Or they may fear retaliatory conduct by an abuser. So when we get calls like these are all issues that we can help individuals with, informing them where the appropriate complaint can be made. We might even make the complaint on behalf of the individual if they don't feel like they have the ability to do so, or if they fear some sort of retaliatory conduct. And so now I have two slides just on where you report abuse and neglect in Illinois. So for individuals 18 or older that are in a Department of Human Services licensed or funded home, that's the Office of Inspector General. For anyone in a nursing home, a hospital, or a state-run developmental disability facility, it's the Department of Public Health. For individuals 18 or older, including adults in a private domestic setting or individuals age 60 or older in the community, that's the Department on Aging. And that's an interesting one. You might be asking, why would I call the Department on Aging for a 19-year-old who's living in the community? Well, this authority was previously with the Office of Inspector General, and it was revealed that they had backlogs and backlogs of complaints that weren't being investigated. So the state took their authority away and has given it to the Department on Aging. So we're optimistic that there's going to be a change and there's going to be improvement in investigation of individuals with disabilities in the community. And then finally, this one is probably the only one that makes sense. For children ages birth to 17, it's the Department of Children and Family Services. So the next issue that I see that I want to talk about is lack of services in a mental health facility. So the definition of neglect from the Mental Health and Developmental Disabilities Code is the failure to provide adequate medical or personal care or maintenance to a recipient of services, which failure results in physical or mental injury to a recipient or in the deterioration of a recipient's physical or mental condition. So this is a really broad definition. It's not including just what you would traditionally think of as neglect. We see this a lot. Individuals call regarding inadequate programming within a mental health facility. So that might be vocational programming. They might not have access to the job training that they think they need. Different types of recreational activities. And then also educational programming is a big one. Maybe they're only allowed to take 1 credit a semester. And that is, essentially, sure.
Are these statutes applicable to residents of Cook County Jail or state of Illinois prisons? And is there a prison line to call?
For abuse and neglect in a prison, generally we suggest calling the sheriff directly for within a prison to report abuse and neglect. there's no specific state agency that has prison. And Laura can correct me if I'm wrong.
Oh, well, I was just going to mention that we do have a class
Yeah,
action against the Illinois Department of Corrections relating to failure to provide mental health services. And then the Uptown People's Law Office and some private law firms have a case, Lippert, about involving medical neglect.
That's why I was
in the
asking
prisons.
if there wasn't a call.
You know, there is an ADA coordinator for the Illinois Department of Corrections. I can provide you that information later.
Thanks, Laura. Yeah, and then so the last I was saying educational programming. So they might not have access to computers or access to beneficial educational services. So possible solutions. Sometimes the first solution and sometimes the best solution in these types of cases is strategies for self-advocacy, advising the client how they can advocate for themselves. So one of the first things I like to tell clients is to request a meeting with their treatment team. This is something that every individual that's receiving services can do. Get their doctors, their nurses, their therapists, their support individuals in the same room to discuss the issue. Take notes during the meeting. Be mindful of your tone. Use words wisely. A lot of times individuals are really upset about these issues, and that makes sense. That's totally justifiable, but that's not always the best way to be received in these types of situations. The first thing I always tell clients to do is to approach it in a cooperative sense, these types of issues. And so then keep an organized folder containing all correspondence and notes. And then my favorite are the last two. I like to tell clients that it's okay to ask questions. So even if a client has a meeting with their treatment team and they feel it went well and that the treatment team was responsive to their needs, I tell them to ask who's responsible for implementing this service. When I have an issue with this in the future, who can I go to ask about this? Because a lot of times we'll have clients that have an issue resolved in a treatment team meeting, and then a couple months or weeks down the road, they're getting the runaround. Oh, that person, I'm not responsible for this. You need to talk to your doctor. Oh, I'm not responsible for this. You need to talk to the director of nursing. So I like to tell clients to know who's responsible. Have the facility assign someone to you that you can address your concerns to. And then finally, request copies of notes, plan of action, and then the plan of action from the meeting. And so similar to the last one, I'll have clients who say the meeting went really well and staff was responsive. And then they request their updated treatment plan, and it's exactly the same. Nothing was written down, no one's accountable. So I ask, even if the meeting goes well, ask for that updated care plan. Make sure that it was written down so that you can hold someone accountable in the future. And so I think a lot of times these issues can be resolved with these suggestions for self-advocacy. And then some other possible solutions are a resident council meeting. A lot of times mental health facilities will have resident councils. Attend the meeting, voice your opinions, and if needed, know how to file a grievance and how to follow up on that grievance within the facility. And then if that doesn't work, you can enter into negotiations with the facility. And it's helpful to have an advocate. That can be a family member, it can be Equipped for Equality, it can be a private attorney. And before you enter into the negotiations, make sure that you know the role of your advocate and make sure the individuals you're negotiating with know the role of your advocate. And then, as always, you can make a complaint to the appropriate state agency to investigate allegations of abuse and neglect. So here's an example of a case that I worked on. So Daniel is a veteran with a TBI, and he's living in a mental health facility. He had a heart attack as a complication from psychotropic medications. And Daniel called because he was concerned he wasn't receiving appropriate physical fitness support to recover from his heart attack. Daniel was really passionate about basketball, and he saw being physically fit and being active was essential to his recovery, and he wasn't getting any support. He could barely walk up the stairs without getting winded. So I reviewed Daniel's medical records. I negotiated with his treatment team to add a physical fitness plan to his treatment plan and had a person assigned that can help him meet those goals. And this was one of those situations where, even though I was in attendance on the phone at the meeting, I requested the treatment plan afterwards, and there was nothing about the physical fitness plan in there. So that type of follow-up is really essential. The next issue is abuse and neglect in a nursing home. And again, these are the definitions of abuse and neglect from the Nursing Home Care Act. Very, very broad. So possible solutions for abuse and neglect in a nursing home. As always, complaint to the Department of Public Health. And if necessary, EFE can provide oversight in that process. Representation in care plan meetings. Again, bring an advocate, bring a list of issues that need to be addressed, and request a copy of the updated care plan. And then additionally, EFE does monitoring visits of nursing homes, where we can do records reviews and negotiate with the nursing home administration, and then also review facility policies to determine if adequate protections from abuse and neglect are being provided within these policies. And then we can also compel these agencies to develop policies that better protect individuals' rights or to change current existing policies. And then there's also a private right of action within the Nursing Home Care Act for abuse and neglect violations. So here's the story of a client named Tom. Tom is an 84-year-old veteran with a TBI, and he contacted EFE from a state-operated VA nursing home, and he reported a litany of quality of care issues. Failure to provide continence care. He was supposed to have his adult brief changed every 2 hours, and it rarely got changed even once a day. Therapeutic diet. He had just had his teeth removed and was still being served food that was not cut up, was not mechanically altered, and he wasn't even evaluated to determine if that was something he needed. Protection from injury. His headboard to his bed was not attached appropriately, and it fell off and broke his nose. And hydration. Tom is diabetic, and he has a risk of dehydration and skin breakdown, and his water, because it was more convenient for staff, was kept away from his bed, and he could never reach it during the day. So Tom was unaware of what his rights were in this situation, and he was hesitant to speak up with facility staff. And I don't want to make overgeneralizations, but speaking with Tom and his wife, this was kind of something he developed from being in the military, that this is how things were, and he was supposed to do what he was being told, and he wasn't comfortable kind of bringing these issues to light or knowing what his rights were. So I performed an unannounced visit to the facility. I met with the client, I reviewed all his medical records, and confirmed several of the issues that he had brought up. And I met with the facility administrator to address my immediate concerns. So immediately, the next day, he had a swallow study done to determine what type of diet was appropriate for his needs. And then I followed up by representing the client in a care plan meeting. Staff were retrained on his needs, and additional support services were added to his plan. And then moving forward, I provided the client with self-advocacy suggestions. I get updates from this client and from his wife, and you know, it's a daily battle sometimes in facilities like this, but now they have the ability and the confidence to know how to address these small issues one-on-one with the facility. And then the next issue that I've been seeing is guardian financial exploitation. And John's here. He is much more experienced in this than I am, so if you want to chime in at any point, please feel free to do so. So what is guardianship? It's a deprivation of the liberty of a person under disability because he or she cannot fully manage his or her affairs. So it can't be just because of the disability. It has to be because they can't manage their affairs. And it's a legal status that can only be established by court order. A lot of times we'll ask clients if they have a guardian and they say yes, and that's because they live at their parents' and the parent takes care of them. And they don't understand that it's a legal status. You have to go to court. It's a court order. And there's 3 different types of guardian: a temporary guardian, a guardian of the person, and a guardian of the estate. And these can be both limited and plenary. Generally, plenary is much more common in practice, and that's because it's easier. It's easier for a court to say that someone can't manage all of their affairs than for the court to decide exactly what decision this person is capable or incapable of making. So duties of the guardian of the estate, they manage the finances. frugal care, management, and investment of the state. They report to the court on the annual income of the individual, and they make disbursements to the individual based on kind of a balancing of the ward's interests and the best interests. So they're supposed to take into consideration the ward, what the ward says, what the ward wants, but they don't always have to, and you'll see in my examples that they don't always do. And then guardian of the person. The guardian of the person has legal custody of the ward. They make provisions for support, care, health, education, professional services, any type of personal decision that you or I would make on our own. And an interesting duty that they have is the duty to maximize independence. So the guardian has to assist the ward in developing maximum independence. And again, in the examples you'll see, it's not something they always do. So possible legal strategies. If you know someone that has a guardian and is being abused or neglected, as always, report to the appropriate state agency. And then additionally, any person, so even if you're not a party to the guardianship case, can express their concerns or request termination or modification of the guardian by writing a letter to the judge. And they can do this by any means. You can call the judge, you can write the judge, it can be very informal. And usually when that happens, a guardian ad litem is appointed to the case, and that's an attorney that's the eyes and ears of the court that is supposed to assess the ward's best interests. And then additional legal solutions that Equip for Equality has done are restoration and modification proceedings. So the ward has the right to request that the guardian be removed or modified, and in these proceedings the ward has a right to an attorney, and EFE is often an appointed independent counsel for our clients in these cases. So unlike the GAL, who represents the ward's best interest, we represent the ward's stated interests. And I'll quickly go through some case examples because I think those are the most exciting. So John is a 51-year-old individual with a TBI. Kind of interesting, he has a private company as his guardian of person, and a large bank as his guardian of estate. He contacted Equip for Equality after his guardian of person refused to discuss restoration of him. The guardian of person was charging him over $115 an hour for guardianship services, which included taking him out to breakfast on the client's dime. So charging him a lot of money, and obviously did not want to lose that. And so EFE has been appointed independent counsel in John's case, and we're now investigating whether or not the medical records support a petition for restoration. And then Sarah contacted EFE after her guardians refused to provide her with an accounting of how her money was being spent, and repeatedly threatened to put her in a nursing home. At the time, Sarah was living in her own home and had a substantial estate. So EFE successfully negotiated for the removal of Sarah's guardians and the appointment of a successor guardian. And in the process of their guardianship, Sarah's guardians had recklessly and lavishly used her money for their own benefit. They paid for their daughter's wedding rehearsal dinner that Sarah was not even invited to. They bought lavish Christmas presents, and then beyond that, just everyday spending at stores that Sarah would never need anything from. And so EFE has filed a motion for summary judgment in Sarah's case, claiming damages for over $140,000. So that was a pretty extreme case. And then these are some mini issues I thought I would bring up quickly if we have time. So often we'll get calls about medical records. So a person that is receiving services for their disability and disagrees with maybe something staff has charted about them or a diagnosis, we advise individuals that they always have the right to review their medical records unless a doctor has decided otherwise. And they have the right to have staff assist them in understanding what's in the medical records, and then if they disagree with something, requesting that it be eliminated or writing an addendum themselves to dispute any information that's in those records. And then finally, involuntary discharge. So the mini case study we have here, individual with TBI is discharged from a long-term care facility in Illinois. And generally, they can only be discharged for one of 6 reasons. So their medical reasons are not being met, cannot be met by the facility. Health has improved, so the individual no longer requires the facility services. Health and safety is at risk, have not paid, or the facility closes. So a lot of times we'll see these types of facilities, nursing homes, long-term care facilities, try to discharge people without the adequate discharge processes. So they need to be given usually a 21-day notice unless it's an emergency. And a lot of times people won't even get that. So we'll advise clients on their right to the discharge notice, and then also their right to appeal that and have a hearing with the Department of Public Health. And so those are a lot of the common issues I see. I think we'll take questions now for both of us.
Definitely. Many thanks to both Beth and Yelena for sharing their expertise with us. We've got a few minutes for questions, and I don't have any right now on the web, so we'll open the floor to the group here. Leslie.
Hi, this is for Yelena. It's kind of hard to understand the different kind of discharge types with no experience. Can you give like a quick example of like somebody did this is other than honorable? Because I just don't.
Can you just repeat the question too?
She was asking about the different discharge types and kind of why someone would get a other than honorable or a BCD or a dishonorable discharge. The only way you can get a BCD or dishonorable discharge is through a court martial. So there would have to be a legal proceeding to kick them out of the military. It's just like a prosecution. The other than honorable and the general discharges are administrative discharges. So it's, you know, like you don't shine your shoes all that well, and it's you know, you don't show up on time, you go AWOL. It's a way to get them out of the military without giving them a full court martial. So it's kind of more of an agreement between the parties. The military doesn't want you anymore. You're kind of done with it. You've been given Article 15, which is kind of disciplinary actions. And it's just to get you out. General discharges are very common. Other than honorable, you can ask for a board. I didn't serve in the military, but we have a retired JAG in our office, so I've learned a lot about this as well. So it just kind of depends on how they were discharged.
But historically, weren't there problems that people were given other than honorable or general discharges rather than honorable for incidents related to mental health?
Yeah,
and that was really quite a scandal, and now they tend to get medical discharges now, which are honorable, right?
Yeah, the question is that, you know, in the past, mental health has been an issue with giving general discharges or other than honorable discharge, and that's correct. Depending, and yeah, homosexuality is another one. Recently, the discharge review boards have realized that service members were kicked out for homosexuality, mental disabilities, and giving a lower than honorable discharge. And that's a way to get a discharge changed. They will take that into consideration when looking at a veteran's status. Say, you know what, there might have been a mental health issue. We really should have looked at treatment rather than discharge. In this situation. For homosexuality, they would have just discharged them kind of automatically, in a sense, where it was like, well, we can't keep you in, and people will get that higher discharge. It's an easy way to get that upgraded at this point.
It sounds like there's no statute of limitations, because we were talking about a World War II veteran could go in now if they had a disability that they think is related to their wartime service.
Yeah, that's correct. There is no statute of limitation for these cases. So you can file, 40 years after you were discharged, which is a great thing with the VA. There, a lot of veterans who have maybe a little bit, too much pride in the military culture doesn't really, you don't really want to show that you have these disabilities. And so, World War II veterans aren't going to, when they get out, they weren't going to file. So now they're 80, 90, 100 years old. These disabilities are really, really affecting them, and they're realizing that they should probably go to, someone who can help them. And financially, they're struggling, and maybe even physically, they're struggling.
Question. Maybe you can clarify for me. When you discuss the total disability based on individual unemployability, was that a separate category of benefits, or is that just a way of getting to the 100%?
TDIU is the question if it's a separate disability or just kind of an addition to other disabilities. It's just an addition to other disabilities. You have to hit at least 60% or 70% to actually even ask for TDIU. Okay. TDIU itself will not be a benefit in and of itself, and the only reason is because you have to show that the disabilities that you're service connected for is the reason why you were unable to work. So that's the reason for TDIU. Mm-hmm.
Right. I work in equipment quality. I do a lot of intake, and sometimes I get veterans, and they have a different issue, or more often than unemployment discrimination. And as a side note, they say, I don't get VA benefits. I don't know why, or I can't. I was dishonorably discharged, but I shouldn't have been. Would that be a good referral for you, or what's your case acceptance criteria? Is it the Chicago area, and who could we send them to?
We don't have a location. We're talking about the Veterans Legal Support Center and Clinic. I should probably bring this up more often. That should be a little plugged for us. We accept appeals for VA benefits claims. So if they were denied, either in the appeals process, or if they want to reopen, we'll take those cases too. That's typically what we look at. There's a way to get around doing an official discharge upgrade. You ask the VA to look at the character of discharge to get it upgraded within the VA system. So we'll take on those cases, but we will not take cases in front of the DRB or the BCMR, which is another way to upgrade your discharge.
And Leslie, I know that LAF does discharge upgrades.
Yeah.
We have time for one more question, if anyone has one. Yes.
If you've seen those ads at night on TV that say, if you've got an annuity or a settlement because of a personal injury case, you can get all your money you need right now, and we'll pay you 80 cents on the dollar or whatever they really will pay. I'm running into this in my calls. Is there any investigation of these purchase of annuities? Sometimes when somebody's mentally damaged in a personal injury lawsuit, they'll have an annuity that pays them a certain amount of living, whether to a guardian or to the person themselves. And a lot of times they're persuaded to cash out on those annuities and sell them. A lot of that appears to be some kind of fraudulent transaction. Has that been investigated, and will you be investigating?
That has not come up in my short practice thus far. John or Laura, have you seen issues with that?
Yeah.
We have not.
Something,
Look at it as
something I can look into.
Financial exploitation.
Yeah, definitely.
Okay, well, thanks again to our speakers. A few housekeeping matters before we wrap up today. The first is, so that Equip for Equality can continue to be a CLE provider, we ask you to please fill out your evaluations. For those participants who are joining us online, could you, to let us know that you were joining us today, please make sure to request CLE credit at the bottom of the form, at the bottom of this website. We also wanted to remind everyone that our next consortium meeting is April 23rd. And we'll be focusing on legal developments around community integration and Olmstead. So thanks again. And I do see that one question came in, so maybe I'll just ask really quickly, since this viewer just asked this question, is has Congress changed the attorney fee provisions? And I'm not sure if there's a specific...
For VA benefits?
Yeah.
I recently, it's 20.
No, it's 20% of presumption is okay.
Yeah.
Anything beyond that, you have to file a petition.
Yeah, 20% is what it is. We don't ask for fees at the Veterans Legal Support Center and Clinic because we are a nonprofit and pro bono attorneys. But if there are attorneys who do charge the 20% fee, and there's EFA fees as well, so equal. There's those EFA fees. I don't remember what it's called.
Okay, thank you. Thanks everyone again. See you next month.